You know, we've had a few chuckles today, thanks to our speakers, but it's really hard to have much humor in a program like this. And I guess we should apologize for that, but I think it would be inappropriate to be lighthearted when you're talking about something as serious as this. And I think when we examine it more closely, and by looking back over 40 years of what was done both by the police and by the citizenry, we all see things we could have done differently. I know that issue about my great friend and mentor, John Hollins, really it was never discussed. And fortunately for us, it never became a legal issue because other than the transfer hearing that you'll hear about in a moment, no real courtroom situation developed where Peggy Morgan would be considered a witness. But certainly as we look back on it now with the benefit of both hindsight and current ethical rules, we can see a real train wreck possible in that situation. The arrest and prosecution of Jeffrey Womack began on August 28, 1979 at 2 a.m. when approximately a dozen Metro police officers descended on Jeffrey Womack's apartment on West End Avenue and arrested him for the murder of Marcia Trimble. Hoping to get a confession from Womack on the way to the police station, two detectives questioned him in the car, but got nowhere. After Jeffrey made bond with the help of my partner, John Hollins, I met with them at our office at 4th and Church. I immediately recognized that even though Jeffrey was now 20 years old and he was still rather immature, that I could not imagine that he was guilty of any serious crime, especially that of first-degree murder. I should point out here that I had been an assistant in the DA's office working for Tom Shriver in 1975 when the crime occurred, but I had no connection with the case at that time. It was all handled in the police department, so I didn't have a conflict myself. But then in '79, when this happened, I was already working with John in his law office, so it was a natural for the two of us to work together. My belief in Jeffrey's innocence was buttressed by the fact that he had already passed at least 2 polygraph examinations, one of which was administered by Captain Noble Brimer of the Metropolitan Nashville Police Department, who was thought to be the best polygraph operator they had. John and I then commenced the defense of Jeffrey Womack that spanned almost 30 years. Now, some people have described our representation of Jeffrey as being pro bono. I think John McLemore wrote an article for the Journal that used those words. And I'm here to confess that the representation was not entirely pro bono. Mr. Womack, the father of Jeffrey, was a very accomplished woodworker. He had a shop out in the backyard, and he had a lathe and so on and so forth. And he gave both John and me a mahogany gavel, which I still have and keep on my credenza, and I got a bowl, which is still in my office now after some 40 years, however long it's been. The only other fee that we got was a donation that was made by the West End Church of Christ. The Womack family had been very faithful members of that church until just a couple of years before the arrest occurred, and they moved to Brentwood, but despite that, that church took up a collection for them and donated $8,200 to the, I guess you'd call it the Legal Defense Fund today. We didn't use those words back then, but that's the full extent of our payment. And quite honestly, the idea of payment never really came up. Partly, I'm sure, because John already had the case, and we've examined a little bit about that, the Peggy Morgan situation. And the other reason certainly was that we didn't think there was anybody else on earth that could represent Jeffrey. We thought we were better suited than anybody else to do it and never really gave it a second thought. In her documentary on this case done by Channel 4 news anchor Demetria Kalodimos, Detective Arlene Moore expressed consternation that almost immediately after the disappearance of Marcia Trimble, Jeffrey Womack had a lawyer. In Detective Moore's mind, that was an indication of guilt. I will say that even though that's completely unconstitutional, that's still a common thing today. Law enforcement officers are allowed to do a lot of things in questioning potential defendants, and one of the things they're allowed to do is maybe trick them a little bit or use things that are not completely true. Some say even perjury. But the other thing is that why do you need a lawyer if you haven't done anything? They'll say things like that. And some people are intimidated by that. In this particular case, there was a very good reason for Jeffrey Womack to have a lawyer, but it had nothing to do with Marcia Trimble, and you've heard a lot about that already, because Mr. Hollins had been called by a former client who happened to be a housewife in the neighborhood who was having a sexual relationship with our client, and undoubtedly part of her motivation was to prevent that secret from being revealed. So much for that, right? However, Hollins' sole concern was the defense of his new client, and I can honestly say I never perceived any conflict of interest in the matter, even though by today's standards it would have been looked at more closely. And I think Ben Cantrell's done an outstanding job of exploring that with you. Let me tell you a little bit more about John Hollins. We've heard a lot over the years about the great class of '57 at the Vanderbilt Law School. It's kind of ironic that John Hollins came into that class more quickly than some, because he was on what they call the senior in absentia program at Vanderbilt, where he was allowed to go to law school after finishing only 3 years on his bachelor's degree. At the other end of that spectrum, you had John J. Hooker, who had gone to a different school but transferred to Vanderbilt and finished with the class of '57. So you had Hooker and Hollins, you had Bill Henry, who was at one of our programs recently, who's now living in Memphis. He was a big supporter of Jack Kennedy in the election and served as a commissioner or a secretary during the Kennedy administration. George Barrett, well-known civil rights lawyer in Nashville, was a member of that class. Thomas Higgins, former federal judge, still living in Green Hills. Tom Shriver, my first boss, my good friend, and as you'll find out in a moment, fellow cave explorer. He was a member of the great class of '57. So this was a whole array of really accomplished legal talent. And some think the greatest of all was Jim Neal, who was the Watergate prosecutor, and as you know, was also a United States Attorney for the Middle District of Tennessee, appointed by President Johnson in the '60s. So these were quite a bunch of guys, and all of them attained a certain amount of notoriety or fame in their own right. But Hollins was a pure lawyer, I would say. He was never really that interested in politics. He did not want to run for office, never considered it, as far as I know. Didn't want to be a judge. He used to joke that in order to be a judge, you have to be fair. He didn't want to do that. What he meant was he wanted to be an advocate for one side or the other, and he was a fierce advocate. He was someone who, once he took the case, he identified with the client, and he fought for that client to the bitter end. And I witnessed that time and time again. In the vernacular of Star Wars, I was his Padawan learner, and he was my Jedi Knight, you might say. And that was a great experience for me, one that I'll always be grateful for. But in this particular case, I think we were of one accord, and that was, there's no way in the world that Jeffrey Womack committed this crime. And frankly, we were amazed that police didn't see that. And we'll probably talk about that some more in the panel discussion later on, but just amazing to me that veteran police officers and an FBI agent thought that Jeffrey Womack could have done this. Because Jeffrey was a juvenile at the time the crime was committed, it was necessary for him to be charged on a petition in juvenile court and the issue of transfer to adult court to be resolved by juvenile court judge Richard Jenkins. Before that hearing occurred, multiple pre-hearing issues developed. The most serious one surrounded the subpoenas which we requested for certain key witnesses, including Detective Diane Vaughn. This is another irony. We asked for a subpoena of Diane Vaughn because we understood that she had found some sunglasses in the garage, in the Thorpe garage, near the time of the discovery of the body. We thought that that would be an indicator of someone other than our client being in the garage and perhaps being the perpetrator. What we did not know at the time we issued the subpoena was that these sunglasses were later identified by Virginia Trimble as being hers, and someone apparently had taken her over to the garage while the police were not present and allowed her to at least look at the place where her daughter had been found. And so it obviously had no meaning in the case, because we never believed that Virginia Trimble had anything whatsoever to do with her daughter's death. But the irony is this: if we had gotten Diane Vaughn in the courtroom and been allowed to conduct a more wide-ranging interrogation, which might not have been real smart on our part, using conventional wisdom of defense lawyers, it might have brought to light some things that you'll learn about later today that Diane Vaughn knew that nobody else was talking about. So be on the lookout for that when Doug Jones gets up here and Mr. Thurman. Judge Jenkins quashed those subpoenas, and his ruling was appealed to the Circuit Court of Davidson County, where Judge Harry Lester reversed the decision and stated that the defense had the right to subpoena witnesses to rebut probable cause. The state appealed that decision to the Tennessee Court of Appeals, and a 3-judge panel, including Judge Henry Todd, affirmed Lester's ruling in setting out the parameters of the defense's right to subpoena and question witnesses to rebut probable cause. This went to the Civil Court of Appeals because it originated in juvenile court, and all the appeals in juvenile court go to the civil courts, not the criminal courts, back then at least. The state's appeal was handled by young Assistant Attorney General John Zimmerman. Now, I promised, is John here? He didn't show. Well, I promised Mr. Thurman that I would do something if he came, but since he's not here, I'm not going to do it. On December 4th, 1979, the transfer hearing was begun in juvenile. I may do it later during the panel, because you're liable to out me on that. On December 4, 1979, the transfer hearing was begun in juvenile court with intense media coverage. The state presented evidence through various police officers regarding Jeffrey Womack's possession of rolled-up coins, a condom, and shoes bearing an obscene word. There was also testimony surrounding the timing of Womack's trip to McDonald's, urging the court to find that even though Womack was 15 years old at the time and was seen by numerous people in the neighborhood, he somehow had the opportunity to commit rape and murder and cover up the crime before being questioned by police officers later that night at the Trimble house. You can tell by the way I have phrased that it seems extremely unlikely. And I think later on we're going to hear from General Torrey Johnson about how they reinvestigated some of that and came to the conclusion that this was rather difficult to prove, if not impossible. Additional evidence was presented regarding alleged confessions by Jeffrey Womack to classmates at Hillsborough High School. And by the way, I had gone to Hillsborough High School, and I can tell you whatever is said in the halls of Hillsborough High School is not admissible in court and should never be. But in this occasion, it was. This evidence was rebutted somewhat by the testimony of several witnesses who stated they believed Jeffrey was only joking and was responding to the many questions regarding Marcia Trimble out of frustration. One of them that the state did not put on had said that they were sure that Jeffrey was joking because he would go on to say, yeah, I killed her and raped her, and then he would go on and say 2 more crazy things. Which made it clear to this witness, at least, that he was just responding because people kept asking him the same question and he got tired of it. Not a smart thing to do, by the way. And you'll hear later, I think, from John Hollins himself that is not something that the police thought much of either, because those statements were made in 1975 and 76, and the arrest did not come for 3 years later, so they didn't feel real confident about those statements either. There was also testimony from State Medical Examiner Dr. Jerry Francisco, who had recently become famous because he conducted the autopsy on Elvis Presley. Francisco stated unequivocally that he believed Marcia Trimble was murdered on the day of her disappearance and that her body had been in the Thorpe garage the entire time. John always thought that Dr. Francisco looked like a fiend in that picture. That was actually taken in the back hallway of juvenile court, you know, the old brick building on the corner of 2nd and Lindsley, where they used to have juvenile court, and of course the place was packed, and so the only place they could get his picture was in the hall, and he was apparently laughing at the time, not being fiendish. On December 6, 1979, Judge Jenkins allowed the parties and the attorneys to go to the property room of the Nashville Police Department to examine the evidence in the case, an unusual step. But I think Judge Jenkins wanted to show that he was giving the defense a lot of latitude here. After returning to court, Judge Jenkins ruled that there was sufficient evidence to find probable cause and that because Jeffrey Womack was now 20 years old, the only possible place for him to be tried was in adult court. And the case was therefore sent to the Davidson County Grand Jury for further consideration. On April 22, 1980, as the January term of the grand jury was drawing to a close, District Attorney Shriver commented to the press that Tennessee law no longer required the submission of the case, the bound over case, to the next term, and he was deferring presentation at that time. The truth is, at that time, Tom and Torrey Johnson, his lead assistant, were re-examining everything that had been done in 1975, including all the work that Pat Apel, the assistant who had pulled the trigger on the arrest, had done, and they were finding that a lot of the things that they had been led to believe about the evidence had not been, was either not true or could not be established well in court. Now, I mentioned Pat Apel. I don't think we have a picture of him, but we have a rather interesting picture of me with an article about a letter that I wrote to Mr. Apel. After the case was dismissed, he wrote, or didn't write, but he actually gave an interview to a local reporter about how he thought, the whole thing was a sham and that he had enough evidence to prove the case and Jeffrey Womack was guilty and all that kind of thing, which under that law, and probably today as well, would have been defamatory. So we wrote him a warning letter, which was required at that time in defamation cases, telling him if he didn't desist, that we would sue him. Of course, we had no real intention of doing that. Interesting thing about Apel, Apel's a smart man. He went to Princeton. He was an assistant for about 2.5 years when he asked for this case to be assigned to him. And one of the things that we may talk about later in the panel is the fact that this arrest in '79 was not accomplished by the A-team of the district attorney's office. It was accomplished by an assistant who may not have even told his boss what he was going to do, which is incredible, and youth guidance detectives, not homicide detectives, who thought they could get a confession on the way downtown and failed to do so, and of course with good reason. Because the press continued to hound Shriver for some action on the Trimble case, he decided to submit the dismissal order on a week when courts were not in session and many members of the media would not be paying attention. This also happened to be a day when I was escorting my former boss and several friends to a cave in southeast Middle Tennessee, something I used to do a lot. And as we walked up the mountain to an entrance to Sinking Cove Cave, Shriver casually mentioned that he was in the process of dismissing the Womack case. As a matter of fact, he was sending Torrey to Judge Leather's court, I believe, with an order to dismiss the case that day. And while I expressed my appreciation for all that, my main thought was to anticipate getting home and being able to call John Hollins and tell him that we had won. That was a big moment. And as I have shared with many privately on this, I give Shriver and Torrey a lot of credit because there was intense pressure on both of them and their entire office, for that matter, to proceed with this prosecution, because many people think that when you charge somebody, that just automatically makes them guilty and they ought to just go right on to court. But they took the high road, and they knew that if they could not get a conviction of Jeffrey Womack, that they had no business indicting him, and that was the decision they made. And it saved Jeffrey Womack from the possibility of spending 30 years in a penitentiary as an innocent man. The reaction of the press was predictable. The Nashville Banner published a cartoon on their editorial page depicting Shriver and me. I don't think the likeness of me is very good. Now, that's Shriver on the left. I don't know. You can't control the press, as some people are finding out. They published that cartoon depicting me and Shriver with dripping stalactites discussing the Womack case, which is not even accurate, fake news, right? Because we were walking up the mountain when it happened. He didn't tell me in the cave, so, so distinction there. I only have a minute or less left to go, and I'm not sure how we are on the rest of the schedule, but I have to say here in conclusion that I think Shriver is one of the most honest men I've ever known. And I think he really just did this because he thought it was the right thing to do. And of course, we're about to find out that he was absolutely correct. So for almost 30 years, John Hollins and I would discuss the case of Jeffrey Womack and speculate on who may have actually committed the murder. We had a long list of potential suspects, but like the police and the FBI, we focused on boys in the neighborhood, and this was the only suspect pool we really could think of. John would often ruminate about writing a book on the subject, but my response was always the same. I did not believe a book on the Trimble case would be successful until the crime was actually solved. And Doug Jones has proven me right on that. His book is very successful. In October of 2007, I left the firm of Hollins, Waxter, and Yarbrough, and after 31 years, to assume the position of United States Attorney for the Middle District of Tennessee. But not long after I got there, I was sitting in my office one day when I received a telephone call from Tom Thurman that would change everything. We're going to take a 15-minute break now. Some of you may want to stay in the room if you're biologically able, because we're going to play the first half of a 30-minute interview that Teddy Bart did with John Hollins just a month or two after this case was dismissed back in 1980. And I think you'll find it very interesting. There's some mistakes in it, but this is the voice of Teddy Bart and John Hollins, two great Nashvillians that are no longer with us.